So Tech Reg and Unholy Alliance. I've approached this on the basis that I'm a practitioner for some 35 years. The experience I suppose I bring to the table, aside from the bio that David remarked on, is really these 5 aspects of my life. And if that doesn't qualify me to be controversial, I'm not sure what does. But let me start by saying that what I find extraordinary about our politicians, and indeed the Parliament, is that they can invent a myriad number of new terms and definitions in the Corps Act for what amounts to good old-fashioned fiduciary duty. But at a recent Senate Estimates Committee, the hearing couldn't define what it was to be a woman. I found that absolutely remarkable. Last year, in October 2021, the Law Reform Commission, which had commenced a review of the Corps Act, an audit, in fact, of the Corps Act, looking at replacing elements that were prescriptive with principles-based text, said that the complexity is likely to be excessive and unjustified, where the prescription is disproportionate when measured against the capacity of the regulated community to understand and comply meaningfully with the legislation. Is it little wonder then that one cannot help but to be swamped, especially in our game, by the volume of statutory provisions and ASIC regulatory guides regulating the financial services industry, from insurance to superannuation and investment advice? The obvious questions one has to ask are, is there simply too much regulation to the extent that it's almost impossible to strictly comply? Is modern technology, as used in the financial services industry, sufficiently sophisticated to enable a licensee or an advisor to interpret compliance duties correctly or at all? Can this technology meet the ever-changing regulations to the extent that it can be relied upon to guide the advisor through the statutory provisions and thereby protect the consumer and at the same time protect the advisor from the repercussions of that? Has the sheer volume of regulatory provisions led the industry into believing that statutory provisions are the only relevant sections of the law when considering compliance, that a rudimentary understanding of statutory law and regulations is all that's required? And 5, has the industry been tempted by the lure of technology per se and taken the easy road to finding solutions, the computer says approach, and along the way ignored the fundamental and traditional approach of using inherent characteristics of common sense and honesty in order to meet the demands of compliance and duty to the client? So, let's have a quick look at the growth in statutory laws and regulations. Let me highlight the growth of the regulatory provisions by simply considering corporate law. Some of you might recall the old Companies Office on the ground floor of the Wentworth Chambers in Phillip Street in Sydney. Some of you may not. But it was a small office within which it dealt with all aspects of the law. It was small and the regulatory provisions emanated from that particular office. The New South Wales Companies Act of 1961 consisted of a mere 385 sections. It was not without its statutory disputes, but it was generally comprehensible, so I'm reliably informed. However, the history of change of control is significant. It was a change from states' control to the Commonwealth in what amounted to a blitzkrieg on statutory provisions and regulations, and has left practitioners of all persuasions gasping for relief. From a mere 385 sections, we now have the Bible, the Corporations Act of 2001, which has grown to a massive 1,692 sections, 35 years after the transformation began. And you would have to say that that is not a long time for so many changes when you consider that it may take hundreds of years, if not scores of years, to change one aspect of the common law. The volume of regulations doesn't stop with the Corporations Act. ASIC issues many regulatory guides, and there are 12 fundamental ethical principles and standards that, in the course of providing advice, provide the benchmark of acceptable client engagement. This is my world, by the way. These must be read and understood in conjunction with the provisions of the Corporations Act. So it's axiomatic to state that the advisor has a myriad of provisions and acts and guidelines that, when piled together, he has a Herculean task in the form of paperwork in which the advisor is deemed to know the rules and which the advisor is to be judged. So that's the mischief, as you'll see there. Is technology the solution? That's the question. Technology is highly applauded, and technology regulatory assistance, as they call it, TechReg, is pushed by ASIC in order to solve the compliance difficulties created by a vast volume of statutory law. The assumption is, if an AFSL invests in technology, then compliance will automatically follow, the advisor will have complied with the duty to the client, and the client will be protected. But the fundamental question remains: is technology sufficiently advanced and specifically targeted to identify all obligations of an advisor and to ensure overall compliance? I'm not convinced that the answer is in the affirmative. So let's look more futuristically at artificial intelligence as the future growth area of technology. Transformational intelligence from Actium guides process automation using robots, and we've heard a lot about that today. Its transformational intelligence claims to be, and I have no reason to doubt that it isn't, so don't take that the wrong way, David, more accurate than trained lawyers. You'll have to think about that one, Nick. More efficient, it can analyse documents in 26 seconds that would take 92 minutes for a team of 20 trained lawyers to do. And Actium has said that they can analyse, or we watched it happen here today, the Brexit Treaty in 43 seconds. I think today the record was 32 seconds from the session that I sat through. And it made me think that, having lived through the Brexit saga, I thought it took Theresa May 2 years and failed the multiple choice section of the exam at the end of it. But I have to say that the 43 seconds, or the 32 seconds as we saw today, was definitely bettered by Boris, because he simply ignored it. So the question arises: are robots the answer to solving the compliance and ethical issues that the advisor and the AFS licence faces each time a client is engaged? It's also axiomatic to state that AI, or transformational intelligence, and other forms of technology will ease the daily business drudgery of data analysis. I don't think there's any dispute excuse me, about that. However, there must be a warning about getting carried away with technology. An example of real-life technology was the intervention of robo-debt technology operating through Centrelink. The robo-technology was hailed at the time by the Commonwealth Government as a huge triumph, cracked down on all the dole blodgers and all the welfare rorts, recovering billions of dollars over a period of just a few years. The song and dance was amazing. The intention behind the technology was meritorious, but the application was woeful and it caused a great deal of harm. An inappropriate logarithm was applied to the revolutionary system. The result was 470,000 wrong debt notices being issued and a total value of refunds at a minor $721 million. So when one considers the impact of regulation on the financial planning and wealth management sector, one has to look critically at technology, including artificial intelligence. As Actium acknowledges, transformational intelligence is not magical, but it may provide outcomes that seem magical. And herein lies the danger for practitioners, licensees and advisors. It's this mirage of technology that's going to come to their rescue. Sorry, I've got a bit of asthma. It's driving me mad. Now, I'm not suggesting that technology has no role to play in assisting the licensee with compliance, or that somehow technology is the problem. I'm definitely not suggesting that. To the contrary, I suggest it's vital to the reform of the modern financial services sector. I don't think there's any argument about that. But let me be frank, technology's present role is limited to reducing, not eliminating, multiple, repetitive and tedious tasks, reducing, not eliminating, human resource risk, improving, not overcoming, reporting efficiencies, and assisting, not replacing, analysis of clients' financial backgrounds and objectives. These are activities of assistance and not of solution, and we cannot and should not fall into the trap of promoting and thus relying upon technologies per se to eliminate or delimit the necessary input of human judgment and conscience into the client relationships, fiduciary duty, or in making an honest assessment of an individual or a licensee as to whether they have acted honestly and fairly. Indeed, operational efficiencies, although easy to measure and, I have to say, seductive in their organisational appeal, tend to do two things. Firstly, they shift the focus, if not in some cases eliminate entirely, the hegemony of core ethical principles towards time management and scale. Now think about that. I'm happy to discuss it tonight. We'll have an arm wrestle wherever you like. And secondly, operational efficiencies shift the focus away from strategic planning towards cost-benefit analysis. And as we shall see shortly, technology does not and cannot address the fundamental abuse of principles that equity has insisted upon over the centuries. After all, technology is not and cannot substitute for the advisor's inherent ethical character. So let's consider an illustration or two. Firstly, the duty to act efficiently, honestly and fairly. 912. I think I've got that up. There it is, 912. A fundamental statutory duty is cast upon an advisor to do all things necessary to ensure that the financial services offered by the licensee are provided efficiently, fairly and honestly. While technology can deal with the efficiency component, it cannot provide a substitute for acting honestly and fairly. These subjective characteristics of honesty and fairness are within the character of the person. And if we move to best interest duty 961B and also the regulatory guide 175, we'll see that this section provides inter alia that a provider must act in the best interest of a client. However, then in section 2, the Act sets out a number of steps that the provider must take in order to satisfy the requirement and thus gain a protection, or what is now colloquially termed the safe harbour provisions. Now, the safe harbour provisions of section 961B2 are limited. They don't cover all of the advisor's duties, including fiduciary duty. They're so structured that the advisor is tempted to follow in rote fashion and conclude, my job is done. A clear danger for the advisor is to literally rely upon the steps set out in subsection 2 by way of a defence to any claim, statutory or otherwise. Section 961B and the RG deals with a situation where the advisor is providing substantive advice. But in the situation where the advisor is called upon to provide advice much earlier in the relationship, gives rise to other issues. The early advice problem has been labelled advice upon advice. And the advice upon advice problem is the early guidance to a client by the advisor about the section and selection of topics on which the client will later receive substantive advice. For instance, in the explanatory memorandum associated with the FOFA Act legislation a few years ago, an example was given of a client who wanted advice on superannuation, debt consolidation and life insurance, but could only afford one of those 3 investment topics. While the statutory provisions and regulations indirectly deal with this such situation by requiring the advisor to provide a financial services guide and a statement of advice, these disclosures are insufficient to specifically deal with an advice on advice situation. It's precisely the early part of the relationship, when advice on advice is sought, that requires a meeting of the minds. And for the Latin scholars at the front table, I've got in brackets here, ad idem. I hope you're proud of me, Nick. It is this early relationship that is capable of giving rise to a fact-based fiduciary relationship. Failure to recognise this could lead to a breach of fiduciary duty. That is, a breach of an equitable principle that the statute does not cover and one that technology does not address. Importantly, as noted by the learned authors Simone Dagerling and Jessica Hudson, a fiduciary relationship may arise at the commencement of the course of dealing between client and advisor. The duty imposed through the fiduciary relationship will not be discharged or removed via compliance with the statutory obligations under the Corporations Act. For example, the advisor may only advise on topics for which he or she is suitably qualified, and you might think that's okay. And however, there's a risk that the advisor might steer the client, even if it's unconsciously, towards the advice areas that the client's qualified to provide advice. And in this example, the advisor gives advice on a topic for which they're qualified, they strictly comply with the Act, they meet the provisions of the Safe Harbour section and the carve-out, but could have committed a breach of fiduciary duty by simply steering the client in the direction of the advice to which the advisor would be able to charge a fee. And there's a subtlety there that the industry needs to get its head around. Technology would not overcome this situation. It falls on the advisor's inherent values, including the characteristic of honesty, to be aware that a fiduciary duty arises and to take steps to avoid breaching that duty. The advisor must recognise that the core of a fiduciary duty is loyalty to the client, and thus, for example, not put his interests ahead of those of the client. Michelle Levy has recognised this in her recent summary under the Quality of Advice Review. She states, amongst many other things, and I have read it, the consequences of providing personal advice rather than general advice are, of course, she says, significant. And so, because many providers cannot or do not want to provide personal advice, or they want to provide advice in their own particular domain, they try to shoehorn what would be more naturally personal advice conversations with customers into general advice. The result is often scripted conversations during which providers deliberately avoid asking questions or using information they have about their customers and speak in generalisations. Now, she's identified that in the current quality of advice review. So no technology, no statutory safe harbour, provision or regulatory guide will assist the advisor to determine if he or she has fulfilled his or her obligations under the principles of equity, such as when the advisor is acting in a fiduciary role. So let's consider a recent court judgment which involved the court analysing the best interests and conflicts of interest duty. In ASIC v Utiqua Lifestyle Promotions, a case where authorised representatives were selling interest in a managed investment scheme, which is essentially time sharing, suffice it to say there wasn't much done right by the authorised reps, and significantly the licence was found not to have taken reasonable steps to ensure that those representatives had complied with the best interest sections, 961. However, what's relevant to our discussion today is the court actually considered whether the conduct of the licensee had contravened section 912A, which is to act efficiently, honestly and fairly. And in doing so, the court referred to the judgment of Justice Beach in ASIC v AGM Markets. Justice Beach expressed the following in his judgment: the words efficiently, honestly and fairly connote a requirement of competence. They also connote not just of even-handedness in dealing with clients, but a less readily defined concept, he said, of sound ethical values and judgment in matters. Even without considering other branches of the law, it's this principle, the less readily defined concept of ethics and other things, that lies at the heart of acting honestly and fairly. It's the ethical value that no amount of technology can match, even with the most sophisticated of algorithms. Perceived technology magic is the quicksand of ethical behaviour. If prescribed behaviours are the enforcement tools of the regulator, and then technology is the answer, then, as Aristotle argued, honesty cannot be seen as a disposition in that environment. So am I alone in making these big statements? Or is there any other support that I might be able to rely on? Well, there is, in fact. Having dug around, I think there is. So let me take you to one small but significant remark of Justice Mashinsky in ASIC v RI Advice. His Honour said that although the duty in 961 is broad, the case law has begun to fill in the contours of what is expected of a licensee by way of compliance with the provision. Now, to me, the court was implying that the interruptions of relevant regulations is very difficult for a layperson, such as a licensee or an advisor, to understand and comply with, and that over time, it's the case law that will assist to make the regulations clearer and enable compliance steps more obvious. Importantly, His Honour did not advocate the black magic of technology, but rather he fell back on the guidance that emerges from real facts examined and commented on by the courts. Perhaps His Honour was reminding us all that we can use technology by way of assistance, but ultimately it will be human experiences and the conduct will determine compliance or non-compliance. Okay, so a further illustration, which is basically a practical example I was involved in, of the inability of technology to overcome these sorts of issues, was when a dilemma arose recently with a licensee. Just make sure this is the right, with a licensee who had to decide whether to report a potential reportable situation or not to report it on the basis that it could rely on a statutory defence. So some brief facts about that. It was reported to ASIC by another AFSL under the new significant breach reporting rules that this particular licensee had received fees from a client, and those fees were based on borrowed funds, contrary to the provisions of section 964D. Two clients were alleged to have paid fees on borrowed funds without the knowledge of the advisor or the licensee. The platform couldn't confirm if there were any loan amounts, and if there were loans, the amount of the loan. The licence did not have access to the platform because it had been sold and was being wound into another platform, so it was big company stuff. Client fees had been paid, but everybody was unsure whether or not these were on borrowings. The licensee made arrangements to repay all the fees in any event. But a couple of questions arose for the licensee. Was it a reportable situation? If so, was it a significant breach? Was the licence under a statutory duty to report the situation to ASIC under those circumstances? So the licensee considered all the facts and concluded it was prima facie a significant breach because it gave rise to a civil penalty under 912. However, the dilemma arose due to the statutory defence offered under 964D, section 3. Was the breach reasonably apparent? Was this within the statutory meaning of when something is reasonably apparent? This key phrase, when is something reasonably apparent, is set out in 964H, and it says, it would be apparent to a person with a reasonable level of expertise in the subject matter of the advice, were that person exercising care and objectively assessing the information given to the financial services licensee. As I say, no amount of technology would assist the licensee to assess this situation. It's a very vexed question, especially when, in this particular case, there were letters flying between the regulator, the licensee, and other people. In conclusion, the illustration highlights the complexities facing a licensee. You might be wondering what decision the licensee made of the last situation. Did it lodge a breach report to ASIC, or did it rely upon the defence? And my response to your wondering is, you need to consider what you would have done in those circumstances. So the points I've tried to make in this presentation, I hope, are obvious. Sadly, TechReg is the bastard child of regulatory overreach and fundamental ethical principles. The sheer volumes of regulations, complexities, and application of equitable principles make the quick technological fix enticing and yet impossible. Technology cannot remove the necessity for a licensee or the advisor to exercise principles of ethics, and the application of those principles will always be bound in the subjective character of the advisor and of those decision makers in the licensee. And in fact, I would go as far as to say that in some circumstances, creating those operational efficiencies has in large part taken people away from some of the more fundamental principles that you would otherwise have found in an organisation simply because they can overcome them by ticking boxes. It's essentially substance, form over substance, and that's a real worry in the financial services sector. So that's about as controversial as I'm going to be. I'm going to leave it there, David, and I don't know whether people have got any questions if they'd like to ask them or if that's the right format. But
Paul, you're going to be here for dinner?
yeah.